Eight,
What?
8 appeal of 2018. 7 years have already passed. 2018 writ appeal. 7 years passed. So still
7 years?
passed in the meanwhile. So matter में
ଆପଣଙ୍କର କଲର ଠିକ କରନ୍ତୁ ଆଉ ସେ ବ୍ୟାଣ୍ଡ ବାହାରିଛି ଆସିବ ଆପଣଙ୍କୁ ଟିକେ ଦେଖ
Criminal appeal of the year 2020. He is in custody since 5/11/19. Live conviction. Prior to
Back to pardon me.
bail petition is pending.
Matter was listed on 8/8/2025. Directed to list the matter to be listed on 1/9/2025. Today it has not been listed. Your lordship.
But this is surface matter. Will be taken up. It's a failed matter. More than 10 years in custody.
Pardon to make a mention, my lord. One CRLA 12 of 2025, my lord. We have filed for interim bail on medical grounds, my lord.
I don't mention a rate petition, trade petition. Trade admission.
What?
Criminal appeal, what? Rate petition.
What is the writ petition? What is the prayer?
The application challenging the illegal application of the illegal action of the State Bank of India.
What State Bank of India has done?
Forfeiting the amount deposited by petitioner.
Okay, give it please.
I didn't mention, my lord. The petition being aggrieved by the inaction of the opposite party in not fixing the pension and recalculation gratuity on the basis as per the Justice Sethi Commission
What
recommendation.
was the petitioner?
Petitioner was working in the district Sambalpur district court of Sambalpur.
the criminal appeal had a face value.
Pardon, my lord, for interim bail.
Criminal appeal. Yes, please give it.
Criminal appeal, my lord, in custody for more than 11 years.
Give it.
Supplemental list. Item number 1.
Item 1. I have received the file 2 days before my.
Yes.
2 days before I have received the file. I have filed my.
Mr. Kashyap was appearing.
Yes, yes, yes.
Okay.
I have filed
Where
my.
is your appearance memo?
I have filed.
Appearance memo.
Already 5 hearings taken place. 5 times you have taken it there.
It was earlier my lord filed an IO for amendment.
Whatever. But
So pursuant to your lordship, sir, I have filed the consolidated petition.
When you have filed?
April Siddha, sir.
Okay, that is on record.
Yes, sir. At last time.
So now what do you want?
3 days adjournment. I will file an date chat. Date chat is in issue.
All right. Appearance memo to the Mr. Vani Shankar Raiguru, and Senior Panel Counsel, Government of India, has filed the appearance memo and submits that since he has been entrusted to argue the matter on behalf of the petitioner, the name of Mr. S.S. Kashyap will be reflected in the cause list and sport. He further submits that he has already filed the consolidated copy of the petition and seeks for adjournment matter till next week. Put up this matter on. You want it next week?
7 days time.
Yes.
7 days time.
No. You want then it will go to week commencing from 24, or you want it next week? Whatever you say. 24. Is this my count? 24/11/2025. Yes.
Item 2.
Item 2, my lord, I am the petitioner. In the meantime, the opposite parties appear in this case, Mr. Tilochon Rathod. I have already served a copy of writ petition.
Oh, there. Whom you have served the copy?
Mr. Tilochon Rathod.
Okay.
You also can put up next week any date of 14.
You have received the copy of the writ petition? Have you received the copy of the writ petition? He
I
said
received a copy of the writ petition.
he wants it next week. Any objection?
My lord, I will file a short reply.
No. Let it. If it is not admitted, why will file?
Prosecutor kindly call it a fresh admission. So
It is coming under fresh admission. What is that? Look on. Mr. Trilochian Roth, Learned Counsel, has already entered appearance for the opposite party. Mr. Maharana, Learned Senior Panel Counsel, submits that he has served a copy of the writ petition on Mr. Rotho, and the matter may be taken up next week. Put up this matter on. It will come on 19th of November. 19th of November 2025. Yes.
Item 3.
My original application was dismissed by the tribunal at the threshold on the ground of lack of jurisdiction, as because there was a restrictive part in the judgment disentangling from financial benefit. I had claimed a financial benefit in that original application. My lord, in the way, I was not seeking to challenge the anomaly of the judgment passed by the High Court, or to review it, or to amend it, or to modify it. I only initiated legal proceedings on a fresh cause of action on the anvil of the judgment. On the judgment, my lord, taking the judgment, the rules have been framed by the Railway Establishment Code. The rule says if punishment has been quashed on the ground of non-compliance of the mandates of Article 311, then the railway employee is entitled to get the financial benefit for the intervening period, from the date of dismissal to the date of reinstatement. On that ground, this I treated as a fresh cause of action and filed that way. But that has been dismissed on the ground of lack of jurisdiction, and as there was a restrictive part in the judgment that no financial benefit will be given in the intervening period, only service benefit.
How can you get over that judgment of the Honorable Court? This court.
My lord, that first part of the judgment, that non-observance of the mandates of Article 311, that is the core content of the.
You approached this court earlier in.
Yes, for a modification of the judgment. I filed an application for modification of judgment. That was dismissed on the ground of limitation, delay.
You approached this court in that petition, which was filed in 2015, and it was decided in 2021, challenging the order passed by the London Central Administrative Tribunal on dated 11th August 2014. Because that was dismissed mainly on the ground of delay. And this court, in that judgment, in the operative part, if you come to paragraph number 26, please come to that paragraph. You have annexed it as annexure 1.
Page 31.
Page 31, running page. Internal page is 22. Paragraph number 26 of this court's judgment.
Hence, the
better you come to paragraph number 25.
25 is better.
25. Okay.
325.
We are of the opinion that since in this case order of punishment has been passed in the year 2004, and in the meantime almost 2 decades have already passed, the interest of justice should not be subserved if the matter is remanded back to the disciplinary authority. We are also of the opinion that the applicant petitioner, who was aged about 49 years at the time of filing of the original application before the tribunal, is near the age of superannuation, and there is hardly 1 or 2 years left of his active service. In such situation, setting aside the order of punishment and remanding the matter back to disciplinary authority will render all his efforts fruitless. Hence, the writ petition is allowed by issuing a writ of certiorari. The impugned order dated 11th August 2014, passed by the Tribunal way number 437 of 2012, is hereby quashed. The order of finding of guilt, second show cause, and final order of dismissal are hereby quashed. We further direct the applicant petitioner should be reinstated in his post as a junior clerk within a period of 45 days from today, with the salary which the other junior clerks are receiving at present in the same cadre. We also direct that the period from 12 May 2003 till his joining shall be considered for the purpose of his service benefits. But the applicant petitioner is not entitled to receive any financial
So
benefit.
this is most
for that.
important.
This line is the
This line is very important.
My lord,
When you
my view is if the first part of the judgment, it is finding
no.
is,
Then remedy is somewhere
so
else.
that is the core content.
No, remedy is
No,
somewhere else. Tribunal can't sit over the appeal over the order.
against this finding, you could have gone to the Honorable Supreme Court. You have not availed it. So now, if that is there, how can the tribunal will sit over, as has been rightly pointed out by my esteemed brother? How can the relief which you are now seeking, that you give me the financial benefit of that period, how can the tribunal will give in view of this particular sentence,
Last line.
last line?
No, that is a distinct part of admit my lord.
Then
But unless that judgment, that operating
That
main
is,
core part
that
of
is the
the
reason the tribunal says that it is as clear. The water is as clear as the deep sea.
then my lord, the implementation of this rule, railway rule cannot be conceived.
That's
There must be a judgment.
But you have resorted to resort to right remedy, challenging this order, whatever. That's your.
So in my view, my lord, doctrine of eclipse should be applied in this case. That part should be treated dormant. So otherwise, there cannot be harmonious construction.
And you moved an application for modification. That was also turned down.
No, that was a dismissal delay
and
ground.
now, if we pass any contrary order, that would amount to review of the order which has been passed by the division bench.
So the judgment is not applied to my.
No, the last line is very clear that you are not entitled to any financial benefit during that period. You have not gone to the Honorable Supreme Court, so that has attended finality. In view of that, how the either the Central Administrative Tribunal or this court can grant you that particular relief. If you can file the review petition in that case, which was disposed of, or approach the Supreme Court, that's a different matter. But how the Central Administrative Tribunal,
When that rule came to my knowledge, the review period was over. It was
it's all right. No, we just suggested that.
it is not a fresh cause of action. I initiate. It's not.
Your cause of action is seized the day this order was passed.
But I think your lordship can apply that
No.
eclipse for the second part. That can be treated as dormant.
It would be stretching too far.
This writ petition has been filed by the petitioner Kalyan Ranjan Sahu, challenging the
Then my lord pass a rigid order.
or yes,
I will try.
order dated 10/9/2025, passed in OA number 260 of 2025. It appears of the next part that earlier the petitioner approached the Central Administrative Tribunal, Cuttack Bench Cuttack, in OA number 437 of 2012, challenging the order of punishment dated 4/2/2004, removing him from service, which was passed by the production engineer and disciplinary authority. The ground of challenge was mainly gross violation of rules, violation of principle of natural justice, and that the punishment being highly disproportionate to the gravity of the charge. The charge against the petitioner was that he remained unauthorizedly absent from the duties for 2.5 years, that is from 12/12/2000 to 12/5/2003. The Land Central Administrative Tribunal dismissed the original application on the ground of delay and being barred by law of limitation. When the petitioner assailed the order passed by the Land and Central Administrative Tribunal dated 11/8/2014 in OA number 437 of 2012 before this court in WPC number 489 of 2015. The same was disposed of by the judgment and order dated 26/4/2021. And this court has been pleased to hold as follows. Quote, paragraph numbers 25, 26, and 27. But last sentence of paragraph 26 underline further. Highlight further. It appears that the petitioner again approached the Land and Central Administrative Tribunal with the following reliefs. You consolidated a original application जोटा file करचंती ताजरे paragraph number 8 रे लेखा है reliefs also quote कर दे. It appears that after issuance of notice, any counter affidavit was filed in the original application against which you have come up to this.
No, that was dismissed on the threshold.
After hearing the Land and Council for both the parties and the Land and Tribunal, taking into account the order passed by this court in WPC number 489 of 2015 on dated 26/4/2021, has been pleased to observe as follows, hold as follows, government. Paragraph number 4 and 5. Government. The Land Council for the petitioner submits that since this court has been pleased to set aside the order of punishment imposed on the petitioner by the disciplinary authority, and also directed that he should be reinstated in the post of junior clerk and further directed that the period from 12/5/2003 till his joining shall be considered for the purpose of service benefits. You joined also in that post.
Yes.
And in pursuance of such order of this court passed in the aforesaid writ petition, the petitioner joined as the junior clerk. He should not have been deprived of the financial benefits for the period from 4/2/2004 to 24/6/2021. Stop. There is no dispute that against the observation which has been made by this court in the WPC number so and so, the petitioner has neither filed any application for review of the aforesaid part of the order where this court has observed that he is not entitled to receive any financial benefit for the said period, nor approach the honorable higher forum. And therefore, we are of the view that the Learned Tribunal on the second approach of the petitioner has rightly held what has been observed in paragraph number 4 and dismissed the original application. Accordingly, we find there is no illegality or impropriety in the impugned order passed by the Land Central Administrative Tribunal. Accordingly, the writ petition being devoid of merit stands to.
My lord, one line was important. My punishment has been first on non-compliance of the mandates, but that
We have reproduced the paragraphs.
Entire
The paragraphs says that. So therefore, you need not be mentioned. Yes.
Yes, next.
Item 4.
Please, Lakshmi.
Yes.
Yes.
So I am the auction purchaser. I have purchased the property to an auction from the bank, Lordship, Eco Bank. And I have
Who has filed that essay?
essay has been filed by the borrower,
The
Lordship.
pleadings are complete.
Yes, Lordship. And Lordship,
Where is the order sheet? You are
I have
paying for a
yes, I have annexed.
disposal of the that.
Yes,
Have you got the order sheet?
yes, Lordship, I have annexed.
But what is your prayer in the petitions? See, closure.
That
Directing
that
closure of it.
disposal of that. You want the disposal of that?
You have to move. Have you applied for it?
You have not moved the.
You should have moved application there.
We are permitting you to file an application.
Yes,
for
Lordship,
expedition.
I am one of the party in that essay.
No, you are to file an application for expeditious hearing of that essay, and we'll give you permission and.
Early disposal of that essay, you have to move an application there in the tribunal,
Right.
and that permission we are giving.
Lordship, my humble submission is recently a Supreme Court judge, Honorable Supreme Court judgment is there to dispose of the matter within 60 days.
You say that to the tribunal.
That we are quoting also, but you see, it depends upon how many cases are pending, how many courts are there, all these things. Are you aware about how many cases of essay are pending with the London DRT? So question is that why your essay, which is of the year 2024, will be given preference over the other essays which might be pending since 4 to 5 years. You are right that the Honorable Supreme Court has observed as follows. But if we directly pass that order, then the others will be also come to us that you fix a date, early hearing, and in this matter we will regulate the entire.
See, the many litigants are not capable of approaching the High Court. So why should they be deprived? Merely because you could come to the High Court. So therefore, you will supersede their right.
Actually, my humble the essay has been after the
we are giving you liberty. Go and look. This writ petition has been filed by the petitioner Raja Naik, who is stated to be the auction purchaser. For inter alia with prayer for early disposal of essay number 42 of 2024, which is sub judice before the Debts Recovery Tribunal Qatar, and it is stated that it was instituted at the instance of the borrower. Right. it is further submitted that the pleadings are complete. But the learned tribunal,
Awaiting for the objection from the bank lordship.
the pleadings are not complete. It is stated that the pleadings are not complete and it is pending for awaiting for objection to be filed by the bank. Stop. The land council for the petitioner drew the attention of this court to the order dated
7th October 2025.
7th October 2025 of the Honorable Supreme Court, passed in a civil appeal number कितने?
Yeah, number in state civil.
Which
In SLP.
arises out of SLPC number so and so, wherein
21255
कितने number कौन?
SLP number lordship.
SLP number we know. Appeal number you find out.
Civil appeal number.
Then we will find out.
Civil appeal number wherein it has been observed as follows: court service
Once
one shuru up to last purchase disposal. We put a pertinent question to the land council for the petitioner as to whether the petitioner has filed any application before the learned DRT for early disposal. The answer was in negative. Of course, the learned counsel for the petitioner has filed the order sheet of the DRT before us. We do not know how many cases of which year are sub judice before the learned DRT for disposal. The land council for the petitioner is not also able to furnish us data. Therefore, directing the court DRT directly to dispose of the case within a particular time limit would not be proper. It would be, accordingly, we grant liberty to the petitioner to approach the Honorable and the learned DRT to file an application for early disposal of the aforesaid essay. And if any such application is filed within a period of how many days you will file that application?
Within 7 days.
Within a period of 1 week, as stated by the land council. The same shall be disposed of at an earliest, and it is made clear that we have not expressed any opinion on the merits of the case. Yes, disposed of.
Item 5.
And filing the EOSN shall notice as the OTS application was pending. And in the meantime, the bank has already finalized the OTS proposal now. That's why I would do this person liberty
has filed memo of withdrawal, which is taken on record. The writ petition is disposed of.
Liberty to any
liberty is always there without that. Always. Why should
yes. Next.
Item 6.
Yeah. I am the option cell purchaser.
Right.
So, may kindly see that cell certificate annexure 4, page number 16. My
problem now.
My problem now the when the cell certificate was issued to me,
yes,
and I paid the required money, cell money, and registration was made. Registration, the draft cell deed was presented before the sub register, but it could not be done because sub register refused to execute cell deed in my favor because there is a litigation in respect of the schedule
security interest. That one case has been filed. The borrower, the son of the borrower, has filed a partition suit in Baleswar Civil Judge Senior Division.
How
And-
can in such a circumstance we direct for registration of that sale deed?
No, I am not
If there
seeking
is
for that.
civil litigation,
I am not praying for that, my lord.
not what you are.
I prayed for refund of my money
Refund of the money with interest.
with interest and
Yes,
with
the property is under dispute. The
Yes.
property is under dispute.
Yes, here am kindly the reply or 6 series, my request letter for refund of money, 6 series,
Where is that?
page 24, 28, to refund my money.
What do we
Then the reply, Your Honor, may kindly see annexure 7 series,
Yeah.
page number 30.
Hmm.
This is important, my lord.
Yeah.
It is from bank that against such malafide auction sale para second para auction notice was published on ATE properly and auction was done on the basis as per the auction sale certificate has been issued to you only after final payment of ATE. So that last para against such malafide the action, however, sale deed could not be executed due to district court order dated 12/9/2022 on the basis of the malafide action of the borrower. Against such malafide action, the borrower, we have already filed a civil suit bearing number civil suit ATE and criminal complaint.
When this auction took place,
My lord,
when the auction took place and when you were declared as the successful auction purchaser,
yes,
and you deposited
yes, my lord. That is annexure 4.
data কোন?
Annexure 4, page 16.
Data কোন?
Sale certificate ଆପଣ କେବେ issue ହେଲା? 2022
ଆଜ୍ଞା 18th December 2022.
ସେତେବେଳକୁ କୌଣସି civil suit institute ହେଇନଥିଲା।
No, not within the knowledge of the bank
No,
or
अरे
whatever.
ଦେଖୁନାହାନ୍ତି।
yes, here ma'am. Civil suit, yes. Annexure 8, my lord, page 31, annexure 8, civil suit, that is civil suit
Of the year 2024.
22.
Woody.
Annexure 8, page 31.
So when are you not aware that when that civil suit was instituted?
No, I was not. I have no.
ବର୍ତ୍ତମାନ କେବେ ଜାଣିବାକୁ ଚେଷ୍ଟା କଲେଣି? If you are taking a ground that you are not communicated by the bank that there is any civil suit pending relating to that property, and even you can take a ground that even by that time also the civil suit was not instituted. That is an additional ground for you, because if suppose
there are two suits said. One suit is in 2022.
Yes.
Because
one suit, no, that is one suit to transfer to another.
Please don't go fast. Come to page 29. First paragraph, one suit is referred to. That is 2022 suit. Okay.
29.
Page 29. Come to page 29.
Yes.
The first paragraph.
Yes, ma'am.
It talks about the suit of 2022, and thereafter in the second paragraph, another suit it talks about 2024. So there are two suits pending, isn't it?
Well, CS number, that is 22.
Yes. Next, second paragraph, just see. Second paragraph, last line, another suit, 24. So therefore, there are two suits pending.
No, civil, the suit declaration of permanent injunction by no, my lord. That is one suit, man. One suit. That is transferred. After transfer, it was number 224.
ଗୋଟେ ଫାଇଲ କରିଛନ୍ତି ସେ ଯୋଉ borrower type ର borrower ଫାଇଲ କରିଛି, ଆଉ ଗୋଟେ ଫାଇଲ କରିଛି ବ୍ୟାଙ୍କ। ସେକେଣ୍ଡ ଟା ଯୋଉ 2024
ଆଜ୍ଞା ବ୍ୟାଙ୍କ ଫାଇଲ କରିଛି, ବ୍ୟାଙ୍କ ଆଫ୍ଟର 2024
ବର୍ତ୍ତମାନ ଦୁଇଟା ସୁଟ ପେଣ୍ଡିଂ ଅଛି।
ଆଜ୍ଞା
ଗୋଟେ ହଉଛି 2022 ର ଯୋଉଟା borrower, ସେକେଣ୍ଡ ଟା ହଉଛି ବ୍ୟାଙ୍କ 2024।
yes ma'am.
We just want to know that since this sale certificate was issued in your name in the year 2022, whether the suit which was filed in 2022 was instituted by that time or it was instituted after that.
Prior to that, after availing loan.
Date kebe CS 22 ro institution date kebe. Notice kebe hela ta jere bank ku. Because you can take a ground that
Notice also suppressed it.
No, my lord, bank is not a party. Bank is not a party, my lord. Bank is not a party.
1 minute, sir.
Look, this writ petition has been filed by Mrs. Ratnamani Nayak. With a prayer for refund of the auction price of rupees 23 lakhs 20,000 and each term price of rupees 1,16,010 along with the interest accrued thereon to the petitioner, who is the auction purchaser. The Land Council for the petitioner submitted that the opposite party number 6 as a loanee and opposite party number 5 as a guarantor did not pay back the loan amount to the bank, for which a proceeding under Surface Act was instituted, and the paper publication was made for the auction sale of the secured asset, and the petitioner became the highest bidder in the auction, and as such, the registration of the secured asset was made by the bank in favor of the petitioner, and ultimately sale certificate was issued to the petitioner on sale certificate here the people on 8/12/2022.
Yes, ma'am.
The Land Council for the petitioner further argued that when the sale deed was presented before the sub-register Baleshwar for its execution, the stamp duty amounting to rupees 1,16,010 was deposited by the petitioner. However, the sub-register Baleshwar refunded the draft sale deed to the bank and did not register the sale deed in favor of the petitioner, mainly on the ground that civil dispute in respect of the secured assets are pending in the courts. The Land Council for the petitioner further argued that after coming to know about the pendency of the litigation, which was not conveyed to him by the bank, he wrote a letter to the bank with a request to refund the deposited amount with interest and also the stamp duty which has been paid by him for registration of the sale deed. But the bank has given reply to the petitioner, which indicates that one suit was instituted by the
Son of the borrower.
son of the borrower,
Partition suit.
and another suit was instituted by the bank. The first suit was of the year 2022 and the second suit was of the year 2024. It is the contention of the Land Council for the petitioner that since there was no fault on the part of the petitioner and being the highest bidder in the auction, he deposited the money with the bank and is now facing problem for registration of the sale deed on account of pendency of the litigation. The bank should have refunded the money with interest as well as the stamp duty amount, which has not yet been done. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Why are you, in view of your limited prayer, why have you added this 5, 6, and 7? You want the refund of the money and all right, requisites for issuance of notice. We filed by speed post with proof of delivery. We filed by next week. You filed the requisites by 14th of November 2025. Put up this matter on such and such date. Objection, counter affidavit, if any, be filed in the meantime. Yes, next.
Item 7.
Item 7, my lord, for next week.
Mr. Dental and counsel appearing in the petitioner 6 for an adjournment till next week. Next week, I go to week for it.
Next week.
Next week. This matter on 12 तारीख को असली चढ़ी on 12th of November 2020. Yes.
Item 8.
Item 8, my lord, challenging the initiation of the sufficient proceeding. The petitioner has already filed one essay, that is essay number 109 of 2023. My lord, there.
Who are you?
My lord, I am the loanee. And he.
You have filed that essay.
I have filed the essay.
Why have you approached here?
The approach is, my lord, during pendency of the essay.
Yes.
My lord, though my application for interim stay was there, but it was not taken up by the learned tribunal. As a result, my lord, when they filed the objection, I came to know that one of the property they have sold it. Instead of putting to auction, they have sold it by negotiation. In Annex 10, they have admitted.
What you want, that interim applications have not been disposed of?
Yes, so many interim applications are there.
No, now which interim application you want to say that it is to be disposed of? You have given 4 numbers, IA.
All are pending.
All are at your instances.
Yes, my instances. Because what had happened,
we are giving liberty move that those
2 properties were to auction. 2 properties were mortgaged.
You want these interim applications to be disposed of.
Specifically, my IA number 1705. So that is important because they have already issued a notice saying me that you vacate the land.
This matter is pending. We will not come up with a particular prayer. You want that those interim application to be disposed of. You are giving your liberty, move to the application, and you will consider.
Well, I have moved so many memos, but it is not being taken.
Then how can we file in a pending petition? IA we will dispose of. IA which is pending there, essay is pending there.
Yes.
We will pass interim order.
No, that the direction to dispose of that that is why
petition has been filed by the petitioner. Into alias seeking for a direction to the
sitting is known and take up from the problem is
for expeditious disposal of the IA number. Once we check the IA number mentioned, which is stated to have been filed.
The Lordship may say 1705. It would be
last IA 1705.
Annexure 8.
4I is for them. However, the land council for the petitioner submits that the land DRT may be directed to dispose of the IN number 1705 of 2025 at an earliest. In view of the limited nature of the prayer, we permit the petitioner to move an application within a period of 1 week from today before the land and DRT for expeditious disposal of the apostate IN number 1705 of 2025. And in the event such an application is moved, the land and DRT shall pass necessary order for if there is no other impediment, take up the interim application on the priority basis for disposal. Yes, next.
Till then, my lord.
No, no question of till then. Yes, item number 9.
Item 9.
Maybe. But here this case is no notice is served on me. Only on last occasion for a takeover notice, they have pasted on our wall that accidentally we got to know. No notice is ever served on as per rule 3 of the Subsidy Act.
Now, what is the stage?
Stage below, they are going to any moment. They have threatened last week by
You are the borrower.
To take over the land. I am
No, the 13 for
notice has never been served on me.
Has it not come to your knowledge?
No, not this is the first notice.
So why you are apprehensive? Let us say that why are you?
It is they have said.
শুনিলে না
না না শুন এই
অর্ডার কাই
অর্ডারটা শুনেছি annexure 5
কোন
annexure 5 এটা পেস্ট করেছেন দি টেক ওভার নোটিসটা দিয়েছেন ফাইনালি দ্যাট ইজ only finally served on me.
No, you
I had no knowledge of the demand notice.
You see that last paragraph what he has been written. The last please refer to our demand notice issued by the authorized officer on behalf of so and so under 13(2) wala
20 ରେ 20 ମସିହାରେ ସେ ଦେଇଥିଲେ
calling upon you to discharge this so and so due on so and so in respect of your so and so within 60 days of this, together with the interest thereon as a people.
They have mechanically
in spite of the above demand notice so and so
you have not paid
failed and neglected to discharge your duty even after the expiry of 60 days notice period. As such, authorized officer so and so has no option but upon the 13(3) ରେ କିଛି ଦେଇନା
ମତେ ଗୋଟେ ନୋଟିସ ଡିମାଣ୍ଡ ନୋଟିସ ମତେ
ଏ ନୋଟିସ କଣ ଆପଣ ପାଇନାହାନ୍ତି
ଏ ନୋଟିସ ବି ଆମକୁ ଦେଇନାହାନ୍ତି ସେ ଖାଲି ଶୋ କରନ୍ତୁ ଯେ ମତେ ଗୋଟେ ସର୍ଭ ହେଇଛି ବୋଲି ସର୍ଭଟା ମେରିଲେ ଏଇଠି ଆମ କାନ୍ଥରେ ପେଷ୍ଟ କରିଦେଇ ସେ ପଳେଇଲେ ଏଇଟା ଆକ୍ସିଡେଣ୍ଟାଲ ଆମେ ଧରିଛୁ
ସବୁ ମନା କରୁଛେ ମୁଁ ନେବିନି
ନାଇଁ ସେଇଟା ହେଲା ସେଟା ମନା କରୁଛେ ତ ନହେଲେ ରେଜିଷ୍ଟର୍ଡ ପୋଷ୍ଟ ଅଛି ତାଙ୍କର ରୁଲ 3 ଅନୁସାରେ
by taking position of this one so. So now you can approach the land and DRT. What is there? So
DRT this given
what prevent you to go to DRT under section 17?
This is immediate action that taking.
Immediate
that is
so many
High Court of decision.
Mr. Mahanti, every week every week some decisions are being rendered that we are passing the order and the Honorable High Court.
It is rather deprecated by the practice of entertaining petition when there are alternate.
When the provisions are not being complied with.
That's right. All these things
no other option than coming to the so I'll take
there is a statutory remedy provided to you.
I am giving you liberty. This has been filed
with the protection
with the petitioner with one so on the prayer order court for them. Mr. Mahanti, Land Council appearing for the petitioner has referred to the notice to take possession of the secure asset dated 24th of October 2025, which has been annexed to the writ petition as annexure 5 and submitted that even though in the said notice it is mentioned that the demand notice dated 26 December 2020, which was issued by the authorized officer for discharge of the loan amount within a period of 60 days has been served on him, and he has failed or neglected to discharge his liability. But in fact, no such notice has been ever served on the petitioner, and therefore the petitioner could not take any step in accordance with against such demand notice, and therefore the bank has not followed the due procedure as available under the Surface Act. Therefore, the issuance of such a notice to take possession of the secure asset under Annexure 5 is illegal and not sustainable in the eyes of law. In view of so and so decisions further, since this court this alternative efficacious remedy is available to the petitioner, it is open to the petitioner to place before the learned TRT all the points which has been raised in the writ petition about non-compliance of the procedural aspects, and it is made clear that we have not expressed any opinion on the merits of the case. Yes, next.
No coercive action till.
No, sorry. So once we are holding that it is to be.
May I just for a moment, there is a decision of this Honorable Court, my lord. In this given situation, it is maintainable.
All right.
So
you go and approach by tomorrow. Yes.
Tomorrow, mother say liberty ଦେଇ ଦିଅନ୍ତୁ. No, ସେଠି ଯୋଉ ଉପରେ ଆମେ ଏତେ କାହିଁକି ଆମେ ଏତେ ବେଗର କାହିଁକି
It is also open to the petitioner to make any interim application for appropriate relief. Yes, next.
Till then protection that no.
Item number 10, your lordship.
If any such application is made, then shall be expeditiously disposed of. Yes, next.
ଟିକେ intelligence ଦେଇ ହେବନି. ଟିକେ intelligence
ସୁଇଚ୍ ବନ୍ଦ କରା
ନାଇଁ ସୁଇଚ୍ ମୁଁ ପୁରା ଡିସିସନ ଦଉଛି, ସୁପ୍ରିମ କୋର୍ଟର ଡିସିସନ ଅଛି, ଆପଣ ଇଣ୍ଟରଫିୟର କରିପାରିବେ, ଆପଣ ଟିକେ ଦେଖିଲେ ତ ହବ। ତ ଦେଖନ୍ତୁ ଯଦି ନାଇଁ ଯଦି
ତାପର ଜଜମେଣ୍ଟ ବି ଦେଖିଛନ୍ତି ଆପଣ, ତାପରେ ବି
ମୁଁ ଲାଟେଷ୍ଟ ଡିସିସନ ଆଣିଛି ଆଜ୍ଞା, ଆଜି ସକାଳ ଯାକ ଖୋଜିଛି ଖାଲି ନେଟ୍ ଖୋଜି ଆଣିଥିଲି, ଏତେ ହତାଶ ହେଇକି ଯିବି ଗୋଟେ ଦିଅନ୍ତୁ, ମାନେ ସେଇ ଦିନ ପର୍ଯ୍ୟନ୍ତ ମତେ ଲିମିଟ ଦିଅନ୍ତୁ, ମୁଁ 2 ଦିନ ଭିତରେ ଫାଇଲ କରିବି, ସେଇ ପର୍ଯ୍ୟନ୍ତ ଷ୍ଟେଟା ଥାଉ।
You are open to the learned counsel for the petitioner cited the decision of this one, so in case it is we expect that if any such application is moved, the learned tribunal shall consider the ratio laid down in this decision in accordance with law. Yes, next.
May I please the lordship? May I please this court? Lordship, item number 10, I mean ratio, your lordship.
Yeah.
Lordship, due to certain personal difficulty, I couldn't appear in person, your lordship.
Yeah.
I may be permitted. Lordship, the petitioner before your lordship is the wife of the deceased husband, your lordship. A loan, commercial vehicle loan was sanctioned in the favor of her husband, your lordship, on dated 24/10/2020, your lordship. And since then, the petitioner, the husband is paying off all the EMIs without any default, your lordship. Not a single EMI has remained unpaid. Unfortunately, your lordship, on dated 23/6/2025, your lordship, the deceased husband, the husband of the present petitioner died, in whose name the loan was sanctioned, your lordship. And till then, your lordship, not a single EMI was remained unpaid, your lordship. And on dated 12/9/2025, your lordship.
You are agreed by what? Agreed by the notice.
Notice annexure 2, your lordship, at page number 29, your lordship.
So you reply 7 days time is given. You all think whatever you are saying us. Go and tell the bank. That's what they have given you opportunity.
I bow down, your lordship. Representation I have given at annexure 4, your lordship.
Yeah.
On dated 10/10/2025, your lordship.
So?
Annexure 4, your lordship. page
Yeah,
number
what do you want
35.
further? What do you want?
Lordship, on compassionate ground, they may consider that because their said
that-
loan was
You have
protected under
given, you
loan
have given,
protection
you have
scheme.
submitted the representation. They
Yes,
will
your lordship.
consider and communicate the order on your representation. So why
Lordship,
have you approached this court? For
Lordship,
what?
they are sitting silent over the same. They
No,
have
no.
already.
How are you apprehensive? See, the representation is 10/10/2025,
Yes, your lordship.
and they have only asked you to give representation. You have given. They'll pass some order. Why are you apprehensive that they will not do anything?
Lordship, 7 days back, your lordship, while the vehicle was on site, your lordship, they have sent 3 people, your lordship. That the EMIs are remain unpaid
All right,
since
this
July.
writ petition has been filed by the petitioner, Dharana Parida, to was the notice dated 12/9/2025 issued by the opposite party bank, with a further prayer for considering his representation dated 10/10/2025 and to take a decision and to settle the loan account in consonance with the insurance scheme. The land counsel for the petitioner submitted that the husband of the petitioner availed a vehicle loan from the opposite party bank, and installments have been regularly paid to the bank, but all on a sudden, a notice has been received by the petitioner on which is dated 12/9/2025, wherein it is indicated that there is a default in making payment of the dues of the bank, and the bank is contemplating to initiate legal proceeding under the provisions of the Surface Act, including attachment of the property. And the petitioner was asked to make payment with interest within a period of 7 days from the receipt of the notice to avoid initiation of the appropriate legal proceeding. The land counsel for the petitioner submit that after receipt of such notice, the petitioner submitted his response to the notice under Annexure 4, wherein he has stated his her grievances and prayed to the bank keep in advance all the recovery actions which is likely to be initiated by the bank. The land counsel for the petitioner submitted that even though the representation was made, the response was submitted on 10/10/2025, but till date no reply has been received from the bank regarding the outcome of the consideration of our representation. We are of the view that since the bank has not passed any order on the representation submitted by the petitioner dated 10/10/2025, pursuant to its notice dated 12/9/2025, no cause of action has arose, which is to be adjudicated by this court. Accordingly, the writ petition is disposed of. Yes, next.
For the bank, the color thing.
The Land Council for this one, so is present to us in the file same color now, which is taken on record. Yes, next.
Item 11.
Item 11. Para is put to have received a 1 week time to file complaints.
The Land
Complied or not?
The complaint
Contesting.
measurement has been made, but little discussion is required.
file for your complaint.
10 days time.
10 days. Mr. Aurobindo Mandil and AC submits that he has received the Parwai's comments on the content petition and is likely to file the same within a period of 10 days. Mr. Bevral and counsel for the petitioner is present, put up this matter on 24th of 10 days on 24th of November 2025. Yes, next.
Item 12.
In item 12, this honorable court has directed to serve a copy of the instruction, which is not yet been served to the petitioner. And as per the last order, I take instructions.
He may be served with a copy of the aforesaid order dated 10/10/2025. 10/10/25 মানে কি দিয়েছিল? He has received the written instruction. Yes, you have received some instruction from the superintending engineer. So you are asked to serve a copy.
In the course date, I will provide.
Lordships, on the last order itself, it was imparted, and on the basis of that, I took instructions, but no compensation has ever been paid to the petitioners. And in the meantime, your Lordships, in the main petition, the petitioner one has moved to the Honorable Supreme Court, and the Honorable Supreme Court has restored the original writ petition. Lordships, may kindly peruse the order.
Just a minute. Once you have taken the instruction, file an affidavit, because they have stated that in this respect, on verifying the record, it has been ascertained that the landowners have been paid the compensation.
Sure.
That is being made. If you say that your client or the petitioners have not received the compensation and it has been erroneously reflected in that particular order which has been, or instruction which has been given to the state, you file an affidavit to
Yes,
that.
Lordships, I'll file now.
Give that.
In the course of the day.
The Land Council for the petitioner submitted that in spite of the order dated 29/10/2025, the Land Council for the state has not supplied him the written instruction dated 10/10/2025 received from the superintending engineer, Cutter R&B Division 2 Cutter. And Council for the state submit that during course of the day, the said instructions shall be handed over to the Land Council for the petitioner. Put up this matter on 24th of November 2025. The Land Council for the petitioner shall obtain instruction on the instruction wherein it has been made, mentioned that the landowners have been paid the compensation amount. Yes, please.
Item 13.
The appeal era 302 case.
As a FOXO matter.
Sure. Life imprisonment. Admit for the trial court record. So you used to get severely
notice.
ପୂର୍ବରୁ ପଚାରିବେ ଯେ ସିଏ ତ କିଛି ଫାଇଲ କରିନି ଏପର୍ଯ୍ୟନ୍ତ, let the council appear ସେ ଯୋଉ council କୁ ପଚାରିବେ ଫୋନ କରିକି, ହଁ ପଚାରି ସେ ଯଦି ପ୍ରାଣୀ ବାର ଦେଇ ଦେଇଥିଲା ହେଲା। Next matter is the same FOXO ଅଛି। ଆଚ୍ଛା କରିଦିଅନ୍ତୁ। Let the Land Council for the state serve a notice on the informant of the case case number दे देवे बादाम पार्ट case number so on so through the IAC of so on so ना and intimate जो काम लिखा हो if he is unable to so on so this counsel from the High Court Legal Services Authority shall be engaged ना yes next
Item 15.
Meet PJ my lord, I am extremely sorry on the last occasion I remained absent.
yeah
Putting this on for trouble. Here the it is a jet criminal appeal and the appellant has been convicted under section 302 and sentenced to life imprisonment and to pay rupees 10,000 in default to undergo further RA for 1 year. And the allegation against the present appellant is that
no Mr. Patnaik you see the paper book is ready
my lord,
and the man is in custody since 2011 so 14 years have already passed so this jail criminal appeal was entrusted to you in 2013 so either you file bail application or you get ready for the hearing of the so what is this case about 302
302 commission of murder of his wife by giving 2 blow with the help of Kati.
To blow in Kati. Why have you not moved application for bail?
Is there eyewitnesses to the occurrence?
There is no witness occurrence.
Then
The
what-
entire
what
case
is
is based
this?
on
Huh?
circumstantial
4 and 7.
3, 4, 7 is an eyewitness.
Yes, page 4 the informed judgment.
Those
Page
3
four.
witnesses, my lord, the
Page
entire
4 to the informed judgment. That has been
my lord, have a glance of both the
No,
paragraph.
let us not factual aspect.
No, my lord. My lord, just have a glance of both paragraph 2 of
the
this.
PW3 4
Seven.
7 are the eyewitnesses who saw the accused running away from.
The eyewitnesses can be.
I am the eyewitnesses that is mentioned.
The PW3 says that he saw he was running away.
Vice. This one.
He has not seen the occurrence.
Actual assault he has not seen. He has seen that the accused was running away with a cutlery and which was stained with blood. That's all. And suppose this evidence remains as such, what further is there?
Further is confessional statement and leading to discovery.
Confessional statement of what? Before extrajudicial?
Extrajudicial confession.
Extrajudicial confession before whom?
No, my lord. 27. That is before.
27.
20.
20. What was recovered at your instance?
That Kati. That.
Kati was recovered. They are PW 12 and 13 are
13 and 12 was declared hostile and 13 has.
अच्छा 3, 4, 7 एମାନେ ହଉଛନ୍ତି running away.
My lord.
ଆଉ
12 and 13.
12 and 13 are the seizure of that witness you through PW 12 hostile.
My lord.
ଆଉ କଣ ଅଛି ତାର ଇଏଟା କରାଉଛି ନା ଆପଣ ଗୋଟେ ଟ୍ରାଏଲ କୋର୍ଟ କୋଉଠି ଗୋଟେ ସମଅପ୍ କରିଛନ୍ତି circumstance ଗୁଡାକ judgment
paragraph 7 ରେ କରିଛୁ.
paragraph 7
First that
homicidal nature of death of the deceased that is not dispute.
That is not dispute.
Okay, there was frequent quarrel between the accused and his wife. Okay, a part ki କହିଛନ୍ତି?
You have 2 sons, PW1 and 2.
PW1 and PW2. Okay, then they heard the screaming sound was heard from the house of the accused. Immediately after screaming sound, the accused was seen running out.
That is 3.
3, 4.
3, 4, 7. And escaping with a cutlery so and so, rushed to the house and found the deceased one. So the whereabouts of the accused, you also you absconded
for 1 day. That is
you were arrested on 36 and Deccanal bus stand at some other place. After the arrest, the accused led the police to the recovery medical opening there and found that this was possible by the weapon of. So main as it appears that apart from other things, this 3, 4, and 7 evidence is very relevant.
My lord.
So what 3 has stated?
They have stated that while they are sitting in their veranda, they found that the accused.
Please come to PW3.
PW3. Running page 53. Second paragraph.
Nilamani was escaping.
My lord.
Nilamani was escaping.
Paragraph number
My lord, 7 months back, 1 day in between 10 a.m. to 11 a.m. when I was sitting in the outer veranda of our house, saw the accused murderer running away, holding a cutlery stained with blood. When I asked as to why he was running away, he did not respond.
Then, at
Seven
the
also.
same time, the doubt created in my mind about some happening, I told so and so that accused ran away with a cutlery stained with blood. Then we all three went to the house and found the deceased. That is the wife of the accused lying in the house in a pool of blood with severe injuries. My house situates at a so and so. Previously, on many occasions, the accused used to pick up quarrel with his wife and threaten to go. So what have you elicited in the so that sound part it is not there in the evidence of PW3 that some screaming was heard by them and then they saw that the accused was running away. That is not there, but
That seven
we've seen
says.
that. Huh?
Seven says.
But my lord, I want to clearly submit that though it was not properly handled by the learned STC, because though it was put to in the cross examination, they are not disclosed before the IO. But I am sorry to say that that is not confronted to the IO.
It is co-paragraph question. It is not a fact that I have not stated
Paragraph
to
6.
the police that I saw the accused running away with a cutlery stained with blood. No, it has not been proved through the IO.
No.
No, is it actually whether he has stated or not?
No, he has not stated because
have
it
you
has been
verified
dealt
the
with, it has been dealt with the lauded trial court.
No, no, let us see that. Who is PW3?
PW3 is Damani Naik. Damani Naik. Damani Naik.
This is public.
ଦେଖନ୍ତୁ ଲେଖା ହେଇଛି ଡମନ ନାଗର PW3 177 ଅଛି ଉପରେ ମାର୍ଜିନ PUT 170 ଆମ ଗ୍ରାମ ନୀଳବନ ସାହୁ ହାତରେ ଗୋଟେ କଟୁରୀ ଧରି ତରବର ହେଇ ପଳାଇ ଯାଉଛି ପରା ନାଇଁ କଣ ଫାଷ୍ଟ ଲାଇନରେ କୁହାଯାଇଛି ତାର ଏପରି ଅବସ୍ଥା ଦେଖି ମୁଁ ତାକୁ ପଚାରିଲି ଖାତି ଧରି କୁଆଡେ ଯାଉଛନ୍ତି ସେ କିଛି ଉତ୍ତର ନ ଦେଇ ତରବରିଆ ଭାବରେ ଜଙ୍ଗଲ ଆଡେ ବାହାରିଗଲା ଅଛି ତ ଆଉ ନାହିଁ କଣ
because it is I have not possessed that document.
No. That's just stated. That is the reason why he might have put that question, but when it was found that it is in fact there, that is how it could not be proved to the IO.
But
obviously,
my lord, kindly glance over the paragraph, page number 14. Criticizing the evidence of P2 3 and 7, the learned SP submitted that both the witnesses have not stated before the police that they have seen the accused escaping holding cutlery stained with blood, and he drew the attention of the Sahoo court to paragraph 4 of the possession period P2 3 and paragraph 5 of possession P2 4, and argued that the evidence should be discarded as it suffers from material contradiction. He further argued that evidence 7 is also not free from doubt. It is brought by the defense that the house of P2 7 is situated at a distance of 100 meters from the house of the accused. It is true that a statement of 161 can be used for the purpose.
What about this man? He is still in custody.
Still in custody.
No. What is your information?
As an outcome.
And how do you say? He might have been released under that premature release. ଆମେ ଡେଟ୍ ଦେଖିକି ଜୁଡିସିଆଲ କଷ୍ଟଡିରୁ କହୁଛି 2011ରେ କଷ୍ଟଡିକୁ ନିଆହେଇଛି ଟ୍ରାଏଲ କୋର୍ଟରେ ବେଲ୍ ନାହିଁ ହାଇକୋର୍ଟରେ ବେଲ୍ ଦେଇନି 14 years ହେଇଗଲାଣି ତାଙ୍କର
I'll take instruction.
That instruction you take and you also get prepared so that
he must be around 70. He must be around 70 now.
ମୋର କନେକ୍ସନ ହେଇପାରୁନି କାହା ସାଙ୍ଗରେ କିଛି ନାହିଁ
ହଉଛି ଢେଙ୍କାନାଳ
ହଁ ମୁଁ ଜାଣିପାରୁନି ନହେଲେ ମୁଁ ବୁଝିଲି
ଓକାଲତନାମା ଫାଇଲ ହେଇଛି ଢେଙ୍କାନାଳ ଜେଲରୁ ଫାଇଲ ହେଇଛି we are bringing it next week ହେଲା ଆଣନ୍ତୁ instruction Mr. Ramanikant Patnaik Land Counsel for the appellant is present. You have received the paperwork.
My lord.
And submit that he has received the paperwork. We have already mentioned in the order dated 24/10/2025 that the accused as per records, was taken into judicial custody on 10/7/2011, and he was never released on bail during trial or during pendency of the appeal. Therefore, he has remained in custody for more than 14 years. Grant counsel for the state seeks adjournment till next week to obtain instruction regarding the status of the appellant, put up this matter on 19th on next week is Aji कितनी तारीख है आज? 7 So we can get it on 12th. This matter on 12th of November 2025. The land council for the state shall obtain necessary instruction in the meantime. 12/11/2025. So you get ready on that day. We can take up the matter for final adjudication if he has not been released on prematurely. So, and yes, next.
Item 16.
I mean, 16, I am in BC, my lord.
Custody
In this
certificate.
case, your lordship appointed to conduct this case, and last occasion, your lordship called for the custody certificate, criminal antecedent, and the conduct of the appellant inside the jail, my lord. And item 16, my lord.
Yes, yes, please wait. Total period के दमो 8 वर्ष 2 मास 28 दिन. And what about the other things? Conduct certificate was good.
Yes, a good conduct.
What about the criminal antecedent? Because here is a case where firearm has been used for killing the deceased. His brother has been to the garden to plant bitter gourd seeds. Accused so came from the backside armed with a country-made pistol and fired at his brother, so abusing in obscene language. Died in the hospital. So, is that information is with you?
First best.
Mr. Budia, the eyewitnesses are there or not?
Yes.
I am only supplied the judgment copy. It's very difficult in my part, but eyewitnesses stated exactly against the present appellant, my lord. But eyewitnesses are there as per the judgment. But exactly, I don't have. Because I have supplied the only copy of the judgment, my lord.
No, the trial court record is available. So in the pen drive, you can take because the paper book has not been prepared. As it is a jail criminal appeal of the year 2022. So you can collect the deposition copies in your pen drive because you have filed an application for bail so that you can move it. So found nothing others. So you file, take the copy. The Land Council for the state has produced the custody certificate, conduct certificate of the petitioner in jail, issued by the Superintendent District Jail Nayagarh. So also the criminal antecedent report from IIC Nuaga Police Station. All these documents are taken on record. Mr. Udhia, Land Counsel for the appellant, submits that since it's a jail criminal appeal and is having only the judgment with him, may be permitted to take the soft copies of the deposition of the witnesses from the trial court record. Let the registry supply the deposition copies of the witnesses to the Land Counsel for the appellant along with the first information report in his pen drive. Yes.
We also may be allowed to take.
Upon level. So also to the Land Counsel for the state put of this matter on 24th of November 2025. Yes.
Madam. Oblige.
Item 17.
By order dated 14/5/2025, your directed the State Council to obtain whether any previous criminal antecedents against the petitioner is there.
Who order?
Order dated 14/5/2025.
14/5.
Yes, you have that report.
It is already on record. Flag D.
Flag?
Flag D.
Flag D.
Yes.
It is ascertained that his address is genuine. That's all right. Nothing adverse was found against him.
Thereafter, Your Lordship has called for the custody certificate and the health condition of the applicant.
State of the health condition कौन पे मंगाया किसी
Merit since because here the case is that he was pelting stone to an unknown person. He was sitting somewhere. PW 16 was there when he was crossing. PW 16 by that road.
There are multiple eyewitnesses. The multiple eyewitnesses and the doctor corroborated.
No rivalry, nothing.
No, health condition माने था age पे मंगाया था
नहीं काढ़े था मुंडो खराब होची कि कौन आगे पत्थर
what is the allegation in this case?
There is no such allegation, Merit, since because we are unknown person sitting there in a road. So PW 16 was there crossing the road in a bicycle. He pelted stone. Somehow he ran away. Then the deceased Rohisuni came to that spot. He again pelted stone. And by the way, died. He succumbed.
Which is stone pelting.
Stone.
Pelting ने तो मुंडरे छेची प्रथमे माने पकेला तो बाजिलानी तब तो छेची था crash
से पड़ियो
9-10 kg रो गोटे पत्थर ताको छेची की मुंडरे.
Eyewitnesses are there.
Yes. Multiple eyewitnesses are there. Eyewitnesses are 1, 2, 4, 9, 11, 16,
Let us
20.
see one eyewitness. PW1.
PW 16 year old may kindly see. He was the injured one.
अच्छा injured eyewitness.
Yes.
PW 16. What
Man. The occurrence paragraph 2. The occurrence took place on 21/12/2016. On that day, at about 11 a.m., I was going towards Saliameta for vaccination in my bicycle to Umma Bahar. On the way, I found the accused was standing by the side of the road and seeing me, he went towards the heap of the stone. As the road was upward, so I got down from my cycle, and by holding my cycle, I was going by walk. When I came closer to the accused, he started pelting stones toward me. I was trying to save myself. The accused pelted 20 to 25 numbers of stones towards me. I asked the accused as to why he is pelting stones towards me, but he didn't say anything. Finally, a stone pelted by the accused hit my left leg, for which I sustained pain on my left leg, and apprehending more injury danger to my person, I left the spot, throwing my bicycle, and started running out of fear towards the pond, where the people were taking bath, and requested them to save me. But none of them turned up to save me, and out of fear, I rushed towards them. The accused took away my bag and medicine box, which was hung up in my cycle, and threw the same in the nearby hill. After some time, the people who were near the pond sent the deceased Rohisuni. Rohit came in his motorcycle, and seeing him, the accused also started pelting stones, aiming at him. One stone hit his head, for which he fell down in a ditch, which was constructed by the side of the road. Thereafter, the accused picked up a big stone and smashed his head by the said stone, for which Rohit
No,
substance
this is he's pointing out this particular that he picked up a big stone and
Yes.
smashed his head by the said stone. It's not that mere depicting ପଡ଼ିଗଲା ପରେ
That is why
ଗୋଟେ
the
ବଡ
Lordship
ପଥର
actually
ଉଠେଇକିନି ତା
Pelting stone
ମୁଣ୍ଡରେ
is regarding the injured person.
ହଁ
Smashing of the stone is regarding the deceased.
ନାଇଁ ଆକୁ ବି ଗୋଟେ ଡିସିଜ କୁ ବି ଗୋଟେ
ଆଗ
ଷ୍ଟୋନ
ହଁ,
ଫିଲ୍ଡ
ପକଡା
କରାହେଇଛି
ବାଜିଲାନି ଯୋଉ
ଯୋଉଟା
ଆଜ୍ଞା।
ନାଇଁ
ପଡିଗଲା ପରେ ତାକୁ ପଥର
stone hit his head
ଆଜ୍ଞା।
for which he fell down
Yes.
in a ditch. Then he picked up a big stone and smashed it on the head.
it's some psyche problem.
That
Yeah.
is why your
That
Lordship
is why the
actually
health condition report is called
But
for, but it appears that it is
only he
health
has a good
condition is good লেখা হয়েছে।
what he see the report. What kind of report is BP pulse check? We have not said that check BP pulse rate at all.
Regarding mental health.
What kind of report?
In the scenario, we wanted the report that about his mental condition.
Physically, he may be fit.
Yes, sir.
What kind of report is this?
This is not the report we wanted.
Weight 65 kilo, pulse 74, BP
While
126.
passing instruction, you must give specific instruction
Mental health.
that mental health.
Some state of some application of mind. So wasting time.
your Lordship was under the impression that he might be an insane person.
That is the main reason why. ଯାହାକୁ ଦେଖୁଛି ପଥର
ହଁ।
ପକଉଛି ତାପରେ ସେ ପଡିଗଲା ପରେ ତାକୁ
Intention ନାହିଁ କିଛି ନାହିଁ.
ହଁ,
No
କିଛି
motive, nothing.
motive ନାହିଁ କିଛି ନାହିଁ ତ ସେଇଥିପାଇଁ
So there is psyche
some
problem.
ସେଇଗୁଡାକ
But
କାରଣ
but
one
get the
this type of
instruction
person comes outside again
No, it may create problem.
ଜେଲ ର କଣ୍ଡକ୍ଟ କଣ ରହୁଛି
Yes.
ବର୍ତ୍ତମାନ ସେ 8 ବର୍ଷ ଉପରେ ରହିଲାଣି
Yes.
ସେ ଜେଲରେ ଅନ୍ୟମାନଙ୍କ ସହିତ କେମିତି ବ୍ୟବହାର କରୁଛି ସେଥିପାଇଁ ମଧ୍ୟ କୁହାଯାଇଥିଲା ଆପଣ କଣ୍ଡକ୍ଟ ସାର୍ଟିଫିକେଟ ତାକୁ ଆଣିନାହାନ୍ତି ଖାଲି ନେଇ ଆସିଛନ୍ତି ଆପଣ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଆଣିଛନ୍ତି
BP map.
ଆଉ ଗୋଟେ ବିପି ମାପି ଦେଇ ନେଇ ଆସିଛନ୍ତି ସେଗୁଡା କଣ ଲେଖନ୍ତୁ the Learning Council for the state has produced the custody certificate which is taken on record. So we, by order dated 14/5/2025, we asked also the Learning Council to obtain instruction about the health condition of the petitioner, keeping in view the factual aspect of the case. But no such report has been produced before us. Rather, a report has been produced which indicates the BP pulse and the weight of the petitioner, and that is in good health. The Land Council for the state takes some more time to obtain necessary mental health condition of the petitioner and also his conduct inside the jail. Apart from obtaining the instruction relating to the criminal antecedent, if any, against the petitioner. Put up this matter on evaluator.
CA report is already there.
Huh?
Criminal antecedent report is already there.
ବାକି କେବେ ଆଣିବେ କୁହନ୍ତୁ କୋଉ ଜେଲରେ ସେଟା ଅଛି ସୁନ୍ଦରଗଡ଼ ଜେଲ ଗୋଟେ ସପ୍ତାହ ଆପଣ ନେଇଯାଆନ୍ତୁ
Next.
ତ 17th ରେ ନେଇ ଆସୁଛୁ
Yes.
this matter on 17th of November 2025. This is taken on record. ସାର୍ ଆପଣ ଇଏ ନହେଲେ ପୁଣି ସେମିତି ଆଉ ଗୋଟେ କଣ ମାପି ମୁପି ପଠେଇ ଦବ
Item 18.
Is convicted for life for the offense under section 302 and 3 years for the
relation of fine ଅଛି ସେଟା allow କରିଦିଅନ୍ତୁ ଏଇ ଯୋଉଟା item number 17 stay fine allow this. Yes, item number 18.
The person is convicted for life for the offence under section 302 and for 3 years for the offence under section
What instruction we sought for in this case? Or nothing? So for it is filed for the first time.
Yes, sir.
So how many years you are in custody?
In custody since 27/6/2019. 6 years 4 months.
What is the case against you?
Basing on the circumstantial evidence and the
302 case.
Yes, madam.
So just a minute. So custody since केबे पहिले?
27/6/2019.
27/6/2019 और circumstantial evidence. So what are the circumstances where it has been discussed?
This one's circumstantial evidence, the last sin theory leading to discovery.
କିଛି noted down ହେଇଛି ମାନେ judgment ରେ କୌଣସି paragraph these are the circumstances.
Paragraph 9.
Paragraph 9.
Yes, madam. Of the judgment.
Page 4.
Paragraph 9 rather paragraph 10 there is. In the case in hand, the prosecution case is based on last sin theory, discovery, statement and recovery of the weapon of offense and conduct of the accused. So last sin biser ki kouchandi?
2458.
Last sin 2458 जैसे कहले कोड समान देखिले तो last sin
Yes, sir. I'll place
यार गोटे प्लेस करो
PW2. I'll start
2
with PW2.
अच्छा all right.
PW2 is the father of the deceased.
He is the
कौन
informant.
देखिले कौन?
The occurrence took place about 3 years back. I, along with my son, had gone to attend a feast where the accused had also come. The accused called my son, the deceased, to go with him to some place. Later, I came to know that he committed murder of my son. I searched my son but could not find him. Later, I found the dead body of the deceased at Begunapada, which was beheaded, and the head was hanging from a tree. Thereafter, I lost the affair.
नहीं ये जिबार कितने दिन पर डेड बॉडी मिला?
After 3 days, madam.
3 days.
Yes, madam.
And the doctor said the death was prior to 72 hours. I'll place the doctor first. That is the PW2S.
PW12 वाला doctor. So it was beheaded, no?
Beheaded. Paragraph the head and paragraph 2 yellow. The head and the body were separated from the neck, and both the body and head were discolored and were black. The neck and the head were separated from the body at C7 level. All the skin and so on. So these are the injuries. Then paragraph 4. The probable cause of death was due to decapitation leading to hemorrhage and severing of the spinal cord, nerves and major arteries to the brain. The time since death was within 72 hours of my postmortem examination.
So Bujiu discovery hela 3 days after.
The occurrence took place on 21/6/2019.
Okay, nahi. Last scene ta kebe kouchandi?
21/6/2019.
21/6/2019.
He gone missing. FIR was lodged on 23/6/2019.
kebe?
23/6/2019.
23/6/2019.
19.
ସେତେବେଳକୁ ମିଳି ଯାଇଥିଲା ନା ଡେଡ୍
ମିଳି
ବଡି? ଏଫଆଇଆର କଣ କହୁଛନ୍ତି?
Missing report.
ତାର ମିସିଂ ରିପୋର୍ଟ ନା ମିଳି ଯାଇଥିଲା?
ମିଳି
ଏଇଟା ଲେଖା ହେଇଛି ମୁଣ୍ଡକୁ
ଅଲଗା
ତେଣୁ ମିଳି ଯାଇଥିଲା ଡେଡ୍ ବଡି।
On 23/6, the dead body was found. On 23rd, PM was conducted, and he says death was occurred in 72 hours prior to the PM examination.
Dead body was found on 22/6 next day.
23, madam.
23.
23, yes.
Yes, madam.
Have you admitted in your accused statement or you have denied it?
All
No, I have
Denied.
denied.
Yes, madam.
ମୁଁ ଘରେ ନଥିଲି ମୁଁ ଜାଣିନି।
ଜାଣିନି। କେତେ ବର୍ଷ ରହିଲାଣି ସେ?
6 ବର୍ଷ 4 ମାସ।
କିଛି ଅଛି କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ଅଛି?
No, madam.
Antecedent we have to
PW
get a report on
12,
PW 12.
yes,
Please,
no, sorry, PW 15, my lord, 15, IO. No, last paragraph,
Last paragraph,
17, paragraph 17.
17.
Yes, my lord.
Conclude.
Page 8, I did not find any previous antecedent against the accused.
Are the learned counsel for the petitioner and counsel for the state? The learned counsel for the petitioner submits that the petitioner is in judicial custody since 27/6/2019, and there is no direct evidence in the case. Case is based on circumstantial evidence, and as noted by the learning trial court, the circumstances are loss in fury, leading to discovery of the weapon of offense, that is Honda,
knife
Knife,
that is knife,
2 knives
and
and
one iron jam hammer.
Knife, in view of under section 27 of the Evidence Act. Our fund also the conduct of the appellant. The learned counsel submits that in view of the available material on record, the chances of success in the case and balance of convenience is in favor, and that the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that PWs 2, 4, 5, and 8 are the witnesses to the last scene, and the dead body was found 2 days after, and it was beheaded, and at the instance of the appellant, life मिला ना, knife ना कौन मिला?
One iron hammer.
Knives and one iron hammer was seized, and the cause of death, as per the evidence of the doctors at PW 12, was due to decapitation leading to hemorrhage and severing of the spinal cord nerves and major arteries to the bank, and the time since death was 72 hours of post-mortem examination. And submits that in view of the available material on record, the petition should not be granted bail. Considering the submission made by the learned counsel for the respective parties, absence of any in view of the nature of evidence available on record, we're not inclining to release the petitioner on bail, and whether but taking into account his period of detention in judicial court and absence of any chance of early hearing, we are inclined to release the petitioner on bail, interim bail, for a period of 3 months. While on interim bail, the petitioner shall not indulge in any criminal activity and shall not try to come in contact with the family members of the deceased. Violation of any terms and conditions shall entail cancellation of bail. I would add for them the learned counsel for the petitioner also pointed out from the evidence of the IO, that is PW 15, that the petitioner has got no criminal antecedent. Anna? Yes, next.
Item 19.
May I please receive? The convicted for 302, my lord, life. He was charged 302 along with 324, but acquitted from 324, my lord. The Lord and Trial Court held the PW8 to be the eyewitness, 3 and 5 are the partial eyewitness, my lord.
Have you got the deposition copies with you?
Yes, sir. Kindly see the 313 statement for us.
3-1?
313 statement of the act. I'm submitting the custody certificate as well as the conduct.
Accused person. Which paragraph? Oh, Muragere Margari, sir.
Paragraph 1, हाँ झगड़ा है इतना मुरागरे मारते नहीं. Thereafter, question number 4.
On 5th सब गुड़ाक मारदेली बेली
मो भाउज को अभिषेक को मारिली
को
କିନ୍ତୁ ପୋଷ୍ଟମର୍ଟମ ବିଷୟରେ କିଏ ଜଣା ନାହିଁ। ମୁଁ ଘର ଭିତରକୁ ଗଲା ପରେ ସେ ଦେଖିଛନ୍ତି ଡରିକି ଗୋଟେ ଘରେ ପଶି ଆସି ମା ଚିତ୍କାର କରି ଡାକିଥିଲେ ଦୌଡ଼ି ଆସ ରବିକୁ ମୋ ବୋଉ ମାରିଛି। ହଁ ମୁଁ ତାଙ୍କୁ ଆକ୍ରମଣ କଲା ପରେ ସେ ଟର୍ଚ ମତେ ଦେଖେଇଥିଲେ। କ୍ୱେଶ୍ଚନ ନମ୍ବର 6 କ୍ୱେଶ୍ଚନ ନମ୍ବର 8 ହଁ ସେ ମୋ ଭାଇ ହେବ ସେ ମତେ ଦେଖିଥିଲେ। ଦେନ୍ କ୍ୱେଶ୍ଚନ ନମ୍ବର 12 and question number 17
17 को पढ़ेगा
yes sir
17 नंबर
yes sir ମୋର ଜୋର ନିଶା ହେଇଯାଇଥିଲା। ମୁଁ ମୋ ଭାଇଙ୍କୁ କହିଲି ଆସ ମତେ ମାରିଦିଅ। ମୋ ଭାଉଜଙ୍କୁ ଖାଇବାକୁ ମାଗିଲି ସେ ଶୁଣିଲେ ନାହିଁ। ମୁଁ ରାଗରେ ଟାଙ୍ଗିଆରେ ତା ବେକକୁ ହାଣିଦେଲି। ମୁଁ ଦୌଡ଼ିକି ଗୋଟେ ନଟିରେ ପଶିଗଲି। ମତେ ମୋ ଭାଇମାନେ ଧରିଦେଲେ। ମୁଁ ମୋ ବଡ ଭାଇଙ୍କୁ ମାରିବାକୁ ଚାହିଁଥିଲି ଟାଙ୍ଗିଆରେ ତାଙ୍କ ହାତରେ ବାଜିଲା। ମୋ କଥା କେହି ନ ଶୁଣ ମତେ ଅପମାନ ଲାଗିଲା।
For this behavior and this honorable part spirit to call for the report matter.
5 months, 2 days, 5 years, 2 days, 2 months.
25/8/2020 mature.
The Land Council for the state has produced the custody certificate as well as the instruction received from the IAC one police station relating to the criminal antecedents. These are taken on record. This matter in January 2026. Yes.
Let's stay relation.
Yes.
Stay relation.
That must have been done.
No matter. I'm fine.
Where you filed?
Today filed my 361.
Huh?
Today filed number is 361.
Let it come on record. Land Council for the petitioner submit that he has filed an application for stay of realization of fine. The said IA be placed on record. Yes, next.
Item 20.
Article per instruction regarding the status of the victim is to whether victim is murderer and also the child man, which is the evidence of the victim.
At the time of due to the occurrence, the victim was pregnant and delivered a child.
That instruction was
staying in Swamiman house.
In the meanwhile, the victim has already got married to someone else, and that child is given in adoption.
What is your instruction, Panda?
Lordship, this is the legality matter, Lordship.
No.
Lordship, in this case, Lordship, kindly see the PW2, Lordship, victim statement.
She was minor at that.
Lordship, she has the minor girl, and accused person is a married person, Lordship, and he has 3 children.
How many years you are in custody?
The custody since 23/11/2017.
What was your age?
So victim is reported she voluntarily eloped with the
कितने वर्ष का भी इतना?
She was 16 at the time of
16. और 23 तारीख को कंप्लीट हुई वो 8 वर्ष. 25 तारीख 26 तारीख. This matter on 26th of November 2025.
That is the statement, victim statement. She was eloped, but she was scolded and मारुथेला सब.
हमें खाली 26 तारीख को रखो चाहो किसी इलेक्शन. Land Council for the state has produced report from the IAC Lycra police station stating the status of the victim and her child, which is taken on record. With this matter on 26/11/2025 as prayed forward. Yes. Next.
Item 21.
Back in Panda Land Council for the informant is presented. Yes. Next.
My Lord, item number 21, on behalf of Rita Singh, one person.
So next week, an adjournment has been sought for on behalf of upon matter on behalf of Mr. Lakiri, Ms. Ita Singh, list this matter. Budhavar Rakhi Dauchu, Asanda Budhavar. Put up this matter on 12th of November 2025. Yes.
Item 22.
22 my lord.
Kundu.
302 offense my lord. And
It's a jail criminal appeal.
yes,
Have you received the deposition copies?
again, paper book receive.
Paper book also.
24 ତାରିଖରେ receive କରିଛି। ଏଇ 24 ତାରିଖରେ କରିଛି। And sentencing her to undergo prison for life and to pay fine 10,000.
What is the evidence?
Evidence my lord.
Is there any eyewitness to the occurrence?
Eyewitness self. Se
Yes.
nije eyewitness.
Nije eyewitness bala?
Wife killed his husband.
Wife is killed his husband.
So we want that whether there is any eyewitness to the occurrence.
Eyewitness कहीं नाहाते आज्ञा.
से कौन है और nije eyewitness कौन?
She is custody in 22/10/2022.
22/2022 में एबे का.
आज्ञा.
So why you killed your husband? Who has deposed against him?
Below 13 minor.
Below 13, who is he?
Brother-in-law. Dear.
What he has stated? I along my father was sleeping on the veranda. The accused and her husband slept in a separate room and others were sleeping in so and so. But the accused in the late night, while crossing from outside, hit on my leg and I was sleeping on the veranda. Immediately I woke up, asked, what is out? What is out? She did not disclose anything.
46 would be relevant.
313 statement. Question number 46 would be relevant.
46. Oh, dear of Deepak. Are
ଆଉ ବାପୁନ ମୋ ସହିତ ଖରାପ କାମ କଲେ ମୋର ଦିଅର ଖରାପ କାମ କଲେ ମୁଁ ମୋ ସ୍ୱାମୀ କହିବାରୁ ମୋ ସ୍ୱାମୀ ମାରିଲେ ମତେ ଫସେଇ ଦେଲେ।
এটা কোন লেডিটা কি?
आज्ञा. आज्ञा. ତା ସ୍ତ୍ରୀ ତାର.
Acha. So what he wants to say that perhaps
she has an implication.
There was she also complained before the husband. Husband did not take any steps. Rather, party करछि ସେଥିପାଇଁ. So that is so. This is the evidence. What about how many years after marriage this thing has happened?
It's confusing.
5 years. अबे आनिचंदी आपण किछि
No minor.
तो नहीं आसुन कस्टडी सर्टिफिकेट आउ तारो जेल कंडक्ट कोन रहुछि हला
Madam, you have to prepare for arguing. Not prepared.
You see, it's a 302 matter and you have been interested because of perhaps you gave your name to be the advocate and accordingly
you have to structure your argument, prepare a note.
And you should show that the confidence which has been reposed on you by accepting the recommendation of the High Court Bar Association is a genuine one. You must prepare it accordingly. So it's a criminal appeal. If you're in the lack of preparation, if the man is the conviction is fund and his life imprisonment remains as such, then that would not be proper to amount to disservice, right? So prepare thoroughly, and because you have got the paper book and whatever documents you want, also you can avail it. And if you want to also have an interaction with that lady, that can also be given to you. If you approach the High Court Legal Services Authority, you can.
Do you have any doubt?
Yes. ତା ସାଙ୍ଗେ କଥା ହେଲେ ଭଲ ହବ।
No,
Do it. You are
whatever you want to. Have you got any experience of conducting criminal appeals before in the High Court?
Yes, yes.
Okay, then you talk to that. Try to ascertain all these things and prepare thoroughly, and you can take the help of others also. Once you have given a chance of arguing a 302 appeal in the High Court, you must fully utilize it. You must have that experience of at least 10 years. Since when you are in practicing?
18 years.
18 years practice. So
Yes.
you have got
2007.
So that must you should bank upon it and argue you have got the matter. Okay. So let the foot of this matter in the week commencing from 24th of November. Yes, next.
Item 23.
In this case, my lord, 3 times my lord already directed State Council to obtain instruction from the.
What modification you want?
Modification my lord 27 तारीख ଥିଲା 27/10 ରେ my lord had this case ଆର୍ଜନ କରିଥିଲେ 31/10/2025 ରେ 26 ହେଇଥିଲା order ରେ ମୁଁ modification ଟା ପାଇଲି.
Well, we are taking up this matter, but why it has come for us? Only for this modification or for something else?
Modification and lordship directed 3 times for taking instruction.
Have you obtained the report?
Conduct of the petitioner while he was on interim.
Interim bail when he was granted?
Last year my lord 4 ସପ୍ତାହ ପାଇଁ ହେଇଥିଲା.
Okay. How many years you were in custody?
Custody my lord 15/9/2019.
Direct evidence now.
My lord, PW15, a son of the deceased, he stated that accused feel that the informant and the deceased stolen some gold ornament from the house.
No, eyewitness is PW15.
15. PW16, 14 कହୁची, he was not, PW15 was not present at the time.
Eyewitness के पचल रहते मतलब. PW15 होची eyewitness.
Again, son of the deceased.
What he has stated?
PW15, my lord, he stated that I am the informant of this case. I know this accused who is standing in the dock. The deceased was my mother. The previous day of incident, that is on 13/9/2019 on Friday, this accused suspecting my mother and me to have committed theft of gold ornament and other articles from his house. The accused abused or filthy language on the next day, that is on 14/9/2019 at about 9 a.m. This accused assaulted my mother by sword on her head and other part of the body, causing bleeding injury, and ultimately my mother died by the assault.
So sword blow given on the head.
Again.
And it is being corroborated by the medical evidence also.
Again.
So PW15 our medical evidence here.
Medical evidence, my lord, of PW.
Who is the doctor who conducted the
Doctor PW17.
17, my lord.
Cause of death is due to hemorrhagic shock, fracture of the frontal and parietal bone, also. So
677 feet, 7 inches.
You have remained only for 6 years, no? ଆପଣ କେବେ ଗଲେ 15/9/2019 because on that day your bail application must have been rejected on merit and thereafter you are granted bail or what?
reject but 4 सप्ताह bail ଦେଇଥିଲେ. Surrender in
so also taking into account the omission and going through the impugned judgment, also the deposition here of the view, and having noted the number of injuries their seat and dimension. We are not inclined to answer. So bail has been rejected on merit. Only ground that you are there was some suffering in the family members. We are inclined to so and so. Now the question only comes about the interim bail, not final bail.
Interim bail.
What grounds you have taken? Apart from that, you have not misutilized the liberty. What is there to be considered now? You have been granted interim bail and you have not misutilized. That's all right. But when your merit it has been rejected, something more has to be found out to grant you interim bail. Otherwise,
what's the ground of for interim bail?
There must be
Wife only.
no, nothing has been stated.
What?
And counsel, please see the bail application. We are because you know that your bail application has been rejected on merit.
Okay.
So you are granted interim bail for some purpose, some family member, something like. In this bail application, there is nothing except that he has obtained. Of course, your conduct is good, but there is nothing that for why we will grant you interim bail.
File a better application stating the real count so that we'll get it verified and we'll pass appropriate order.
For interim bail, there should be some ground. If suppose there is family health issues, so many things, but you are not stating anything. That wife's element which you are stating, there is nothing, neither the averment nor you have annexed any document in support of the element of the wife. So better you take instruction.
File a better one or file some document, something.
We are taking that on record that you have not listened. The Learning Council has produced the report from the IAC Sorda police station dated 7/11/2025 to show that during the interim bail period, the granted by this court as per order dated P9/2024. There was no adverse report against the petitioner. The written instruction is taken on record. The Land Council for the petitioner submits that he intends to withdraw the interim application and file a better one. According to the IA is disposed of as withdraw. Data IA number since like I would like to the modification of the order dated so and so. It appears the Land Council for the petitioner that inadvertently in the order dated so and so, it has been typed out as so and so, and therefore the matter may be taken of so and so. In view of such submission, the IA is disposed of, and the IA is taken up today. IA you bail this, he wants to withdraw this application to file a better one. Yes.